Joining me now is Andrew Weissmann, former FBI general counsel and former senior prosecutor on the Mueller investigation. Andrew, we want to talk to you about the law and what you see out there, not about the politics of all of this, although the president is saying that, he can go on the attack against prosecutors, as he has in the past. Is there any way to judge just how close the special counsel might be in deciding whether to recommend a prosecution? And that's a recommendation that the attorney general would have to follow unless it falls way outside the legal precedents.
So the answer is we don't know. Okay. We don't know with respect to the two federal investigations that you noted, Andrea, and the Georgia state investigation and the Manhattan DA. All of those are pending criminal matters. I would say the one that we have the most intel is the Georgia state case, and that's because the DA said several weeks ago that a decision would be, quote, imminent, unquote. Now, what imminent means is something that you and I and a lot of other people have speculated, but that could obviously be any day now, that there are state charges. I think just in terms of your reporting about what the former president said, it's worth remembering that he is the person who made the federal search in Mar-a-Lago public because he thought it would help his standing and his numbers, as he suggested, and in fact it did. So, he may be very right that this will help him. It's certainly in the primaries, but it remains to be seen, and this is for political pundits, not really for me, whether it would really help in the general election if he is actually under state and or federal indictment.
And he's proved to be a master of using legal challenges to delay cases. Could he delay so long as to get into that realm where the Attorney General under Justice Department policy would not want to prosecute because he is a candidate and the election is imminent?
If he could delay the decision for over a year and he fell into the sort of 60 to 90 day window before the election, then the answer is yes. But I think the strategy is more likely to be that if there is an indictment before then, and I think that if there's going to be one, I think that both the state and federal cases will happen before then, is that he is also a master at throwing, sand in the gears, and he would slow up any trial either at the state and or federal level. And there are many, many ways and many novel legal issues that he could raise, whether it's the supremacy clause, whether it's immunity for presidential actions. I mean, there are a whole host of issues that the courts would have to deal with. So we could be in a situation where he ends up being indicted at the state or federal level, but there is no trial until after the presidential election.
And he filed a motion already with the federal judge reportedly trying to block Mike Pence from testifying to a grand jury, citing executive privilege again. Does he have a basis as a former president for asserting executive privilege?
So the answer from me and many, many other people is that is a loser, that he probably does not have executive privilege because he is a former president. But even if the court conceded that a former president can assert executive privilege, that is a privilege that is weighed against the need. And here, if it's in the connection with a criminal case, that you can go back to the Nixon decision where it's pretty clear that this would come out against the former president. So that seems like a very weak argument on his part.
Andrew Weissmann, as always, thank you so much.